Good morning again. I put something together which I hope will be helpful for everyone. What I'll be covering, what I'll be covering will be issues on the area of Hawaii's recording system. How does a commitment for title insurance help you? Real property tax credit versus exemptions. Red flags you can look for in a commitment. Understanding tenancy laws. Understanding notarial requirements, and why documents are not accepted for recording and discount that can help your client. Real quick, like Hawaii is unique. It is the only state that has a dual recording system, both at the same area. We only have a single recording area called the Bureau of Conveyances. Other jurisdictions on the mainland are run by counties. Hawaii is the singular state-run office called the Bureau of Conveyances with two recording systems. Most of you are aware of what we call the regular system that was created back in 1859 as a means of registering property ownership in the state of Hawaii. Since that time, you can identify those documents. If you see those documents, it'll refer to book and page, library and page, the year and the document number, and currently they're identifying documents in the regular system with an A for abstract and then following number. So you see that A in front of a number, that is your regular system document. Also references that will let you know it's a regular system property. If you see the word file plan in your description, that is an automatic reference to regular system parcel. File plans are only used in regular system as properties are subdivided. Land Commission Award, Royal Patent out of the original Mahele, that's a reference to regular system. The document numbers will be an automatic flag. And recording system, if you look at document, will always appear on the upper right-hand corner of the document. Land court, on the other hand, is a judicial process that was created in 1906. It was to meet the demands of people being confused as to who owned the property because of the similarity in names. So they started an application process which created what we call land applications and properties under land court. And once the property has been adjudicated by the court and said that you own it, a certificate of title was issued in the owner's name. As properties were subdivided, they took on different map numbers in those lots. So you start with map 1, you subdivide it, it'll be map 2. You should further subdivide that, it becomes map 3. So land court properties are always referred to as lot number, map number under a certain application that is perpetual. How do you know it's a land court property? By the document number. Initially, land court only issued document numbers by itself. Currently, land court property is identified with a T that stands for torrents, the system that the land court was patterned after, followed by the number. The land court also has a specific requirement of no initials. Full names are required, except in those instances where a trustee is taking title, initials can be used. However, if there are individuals holding title to real property in land court, it has to be with full names, no initials. I did run into a few instances where the initials were their full and legal name, and it was referenced in the document itself. Well, how do you know it's land court? If you look at the descriptions, it'll refer to certificate of title numbers, application numbers of the owner, and recording information is always on the left, upper left-hand side. You start the process of a sale, that the initial thing you'll receive after the broker's spree will be a commitment for title insurance. The commitment basically is the underwriter's offer to ensure that purchase or that ownership by virtue of a search on the property and reflecting what needs to be cleaned up in order for clear title to pass. Your commitment basically starts off with a Schedule A, and it basically gives you the effective date of the commitment, gives you who owns the property, the proposed buyers or sellers, policies to be issued, how much is to be issued, and who the party that currently owns title to that parcel. Schedule B are requirements that need to be satisfied in order for the policy to be issued. Pay close attention to these requirements, because if they're not satisfied, title insurance will not be issued. And a B2 exceptions are basically those things of record that would have to be cleared. Some things will not be cleared. There'll be references to mineral and metallic rights reserved to the state of Hawaii. That is perpetual. But if there's mortgages, liens, other encumbrances, the requirements would reflect those have to be cleared in order for a title policy to be issued. In general, your commitment looks like this. It's a cover page outlining what you will receive at the time of closing. It's a sketch of what needs to be cleared, what needs to be resolved before a full title or clear title can be given to you. This is Schedule A, shows the current owners and what they want to, and the buyers and how much they want to get. The estate, they describe the estate as being in fee simple. And then they show who owns the property at the current time. So that's your Schedule A. Schedule B requirements reflects what things need to be done. And in general, pay all the fees that are due on the premium charges. And in this case, release of mortgage dated blankety blank. That has to be cleared in order, and a premiums paid in order for title to be issued to the owner for them to be secure in their ownership. An exception that'll follow the property are your normal real property taxes, taxes that go with the property, easements, things of the nature that are recorded. We deal with recorded information. Anything that's recorded will be reflected in this exception area, except for those that we know to be perpetual, such as mineral rights and water rights. As you go through the process, you've heard of home exemption, which has increased this past fiscal year. Tax credit. One of the issues with this is there's a difference between both. Under the home exemption, that's an automatically given to people of a certain age. They have an increased home exemption, or your basic home exemption for home ownership. If you're a primary owner, you're allowed to get that exemption, and then it's reflected in your real property tax for you to save some payments against the real property tax itself. That is perpetual for as long as you own the property. It is not revocable, and they're not going to collect it if you sell the property because of the home exemption. It also put money in your client's accounts by knowing about tax credits. There's a real property tax credit for homeowners based on income, disability that has to be applied for. Following the rules, you just go to the city and county and they have the rules based on what would qualify for multiple credits, not a home exemption, credits, which will be applied for and approved. That has to be submitted by September 30th of each year along with the home exemption claim. When you look at the real property tax records, look out for unknown surprises. In this particular instance, at the top, there's an exemption, building exemption, home exemption. That's been increased this year. However, if you look at the historical tax information, there's some information that you should pay close attention to. One is which is the tax credit, the $2,364.25. That is a credit that's issued by the Real Property Tax Office. However, if the property is sold within the fiscal year, that monies are refundable back to the county. The seller would have to pay for that. Otherwise, the buyer will receive a notification in the mail that they owe the balance that was not paid at closing. So we at escrow, we have to be cautious of that because we don't want to have anybody be surprised by having to pay additional monies because something was overlooked. This year, there's a $350 tax credit for homeowners, which is divided $175 for each pay period. Be aware that if the property is sold within the fiscal period and you notify the tax office, the home ownership exemption is stopped, and then the money is due back to the county. The $350 is only being given to those people that have approved home exemptions. If they don't have a home exemption, the $350 credit does not apply. However, be aware that once the home exemption is canceled, that tax credit of $350 or $175, whichever half you're in, is gonna be deducted from the sale proceeds, but that has to be returned to the county itself. Let's look at some red flags to see in a report. This is a Schedule C that also is part of your commitment for title insurance. In this particular exhibit, if you read through the exhibit, I've highlighted two areas. One, the area of the lot being 16,109 square feet, saving and accepting a certain 1,246 square feet conveyed to the city and county of Honolulu for road purposes. That is the exhibit that appeared. That is what's recorded at the Bureau of Conveyances. That is the only recorded description of the property to this time. However, if you go to the plat map refers to a lot with only 15,068 square feet. There is a difference from the real property tax description and the original deed and the subsequent deed and the actual plat map. So it leads to some confusion. Some people get confused as to why is there a difference. We had to review the situation, and what happened is the original lot, 16,109, was created in 1948. In 1970, the city and county took 1,246 square feet from the parcel for roadway purposes. However, in 1987, the city re-designated the roadway area and conveyed back 205 square feet back to the original owner. That was in 1987. In 1988, the property was redescribed, resurveyed, and the new meets and bounds were created, reflecting 15,068 square feet. But that subdivision or that renewed map was never recorded. So on the surface, although it looks like it's incorrect, the plat map is correct. What we had to do was get the new meets and bounds for that particular lot to record with the conveying deed currently to change the meets and bounds to reflect the proper lot size of 15,068 square feet. That was an issue we caught as we were going through. This is another issue of red flag. Malia Place. It is a sanctioned street. It's serviced by the city and county. But if you notice, it has a tax map key number of 43. 43. That was a red flag to us. We believe that was a private ownership and it is privately owned. And so doing our search, we found no recorded easements over that particular Malia Place for the lots being serviced by it. And our reports reflect the following: lack of a recorded easement over Malia Place to a public highway. What does this do? In order to get a recorded easement, one would have to go to the individual owners owning 43 to get access rights over those individuals. In this particular case, it was decided it would take the property subject to the lack of a recorded access, because at this present time, the city and county does service money in place pursuant to their ordinance of their facility maintenance ordinance that requires them to service roads that service more than 4 to 6 residents. So they maintain that road. So the people were happy with that. This is another issue we have. These are two separate plat maps, but they look identical. Everything is the same. The lot numbers are the same, parcel numbers and lot numbers. What happened on this one, the party bought 2 lots, one from each of these blocks. But they combined it in a single block where they did the most recent deed. So we picked that up. Because they, instead of being parcel 65, flat 65, flat 54, there were one in each one. They combined the lots and they went with, they said the right tax map keys, but they combined the lots. One was block 94, the other was block 268. They combined the 2 lot numbers and only referenced block 268. So that created an issue. The correction deeds had to be done in order to make sure that their ownership reflected 1 lot from block 268, another lot from block 94. So we had to separate that through a correction deed. Those are things that we look at, although the tax keys were the giveaway, the lot reference showing the same lots for the 2 properties was another red flag that we assured on that. Tenancies, everybody knows tenancy, right? Tenancy in several T's, a single person. Joint tenants means right of survivorship. In other words, if one dies, it just passes on to the surviving owner. Tenants in common is an undivided interest. It's not, there's no right of survivorship. It's held in common for that individual in perpetuity. It cannot be, if that person died, it just goes to the person's heir. And tenants by their entirety, husband and wife, reciprocal beneficiaries, both own it 100%. It is not 50-50. It requires both sign in order to execute any transaction with that particular interest. So let's go to a real fast exercise. Okay, we start off with Elmer Fudd, Roadrunner, Bugs Bunny, and Daffy Duck as joint tenants, which technically means they own 25% each. That's basically how joint tenancy works. Then Daffy Duck decides it's too far for him to fly from the West Coast to Hawaii all the time. So he sells his interest to Donald Duck. I'm sorry, to Bugs Bunny. So that remains Bugs Bunny, Elmer Fudd, and Roadrunner. Roadrunner decides he's going to try to outrun a train. Unfortunately, he doesn't make it. So the property now is moved, and it is Elmer Fudd and Bugs Bunny remaining on property. Interest so far. Bugs Bunny decides he was hungry, so he goes into a garden, which has just recently been poisoned. He eats one too much poisoned carrot, and he passes away. Question, is Elmer Fudd the sole owner of the property? Some will say yes, some will say no. Some will say no because they don't know. Some will say yes because it seems like it's appropriate. However, realizing the tenancy laws, What happened here? Bugs Bunny's 25% that he acquired from Daffy Duck is still a separate interest. It also stands true that interest is also standing alone when he dies eating those poison carrots. So the end result, based on the tenancy provisions of joint tenancy, the joint tenancy was broken when Daffy Duck sold his 25% to Bugs Bunny. So Bugs Bunny owned an undivided 25% on his own, as well as retaining some rights as a joint tenant. When Bugs Bunny passed away, technically it was Elmer Fudd and Bugs Bunny at the end. Bugs Bunny passes away. Elmer Fudd owned 3/4 of the interest. Bugs Bunny, his heirs and devisees, hold 1/4% of that interest. So that has to be probated. Elmer Fudd's interest of 3/4 is easily shown to the passing of the other owners. That's a quick test on tenancy. Notary publics. Those are standard stamps. What you want to pay attention to in your notary public is the venue, which is the state of Hawaii, city and county of Honolulu, state of Hawaii, city and county of Honolulu. That is standard in all venues. State of California, it's only going to show county of San Diego. City and county is basically only used for, that I know of, in Honolulu. But that venue has to be completed. If it's sent away for signature, it cannot be left blank. It needs to be reflected all the time. Both notaries' acknowledgements look alike. However, there's a law that requires, that the notary certify the document itself in terms of what it is and where the document was signed. In this particular top one, signed in the First Circuit. The second one, there's no reference to where the document was signed. So in this particular case, there's an additional document that's required, is a certification statement by the notary where and when the document was signed and in what jurisdiction. That is a standard phrase and requirement for all documents being notarized. What if the client is out of state in a foreign country? They can go to the consulate or the embassy to get it notarized and acknowledged there. Military, they have the Judge Advocate General that can acknowledge documents for them, but that doesn't create it. So we do a lot of JAG acknowledgements for active duty personnel. This particular situation here is a notarial certificate in Japan certified by an apostille. The apostille is something that came to an agreement with the Hague Convention back in the earlier days, where all countries got together and adopted this apostille to certify documents acknowledged in their country to be recorded and accepted in other member countries. So in this particular one, it is from Japan. The Japan notarial certificate was done in Japan. The apostille that was attached to it by the Ministry of Foreign Affairs, that has to come together in your document. The notary by itself is not going to be sufficient. The apostille by itself is not going to be sufficient, because the apostille certifies the notary public. And most recently, the remote online notary, that has been accepted by the state of Hawaii, where we can do online notarization for people in foreign countries, provided appropriate identification is provided for the notary to substantiate that person is actually who that person is. So as far as acknowledgement, those are critical forms that are required in all your closings in order for it to move smoothly. With the consulate or the vice consulate or the embassies in foreign countries, one of the problems you might run into would be the delay. So the remote online notary comes into play. In Japan, some people just cannot get to the area that the apostille would be given. It takes them hours to get to them. So remote online notary has been a godsend for them. So you're ready to record and you find out the documents are rejected. Some of the rejections, these are just samples of what the Bureau rejected for. Some of the most common ones on rejections, venue. The venue is incomplete, it's incorrect, or it's not filled in at all. So the escrow people would have to make sure that's completed. If you're reviewing documents and sending with the client, make sure that's also completed. AKA, the use of AKA. In the regular system, that may pass, but in regular system, AKAs are never accepted. It cannot be Carl T. Watanabe, also known as Carl Thomas Watanabe. The ownership under the certificate shows Carl Thomas. That's how documents have to be prepared. We run into a lot of problems with the AKA with mainland lenders that believe that it's appropriate to do it without understanding the local rules covered by land court registration. Power of attorneys. We had an issue the other day where the power of attorney came in. It was for a bank, but the abbreviation on the power of attorney did not agree to how title was held on the certificate. So that power of attorney had to be returned. And we were in constant arguments with them. They're saying that's the same bank. However, regular system might have taken it, land court had to reject it. And we went over and over that. And that's where land court becomes an issue. Mortgage to trust. We see a lot of documents coming in where mortgage is being made to a trust. Carl Watanabe as trustee. So the signature line, they put Carl Watanabe twice because they're taking Carl Watanabe's signature as a secondary guarantor on that mortgage, although Carl has no interest individually on the title of property. It's been rejected because they put the two signatures and the notarization, although it's okay to reflect that Carl Watanabe as trustee acknowledged the document, they're looking for a secondary phrase saying Carl Watanabe as trustee and individually. And the argument that Carl Watanabe individually does not own the mortgage or has no title interest in the mortgage. The simple fact that Carl Watanabe was required to sign the mortgage as an individual, the Bureau is looking for a notarial acknowledgement specifically for Carl as an individual, or together, if it's worded in the acknowledgement, Carl Watanabe as trustee and individually to make that mortgage pass. So these are some of the common areas of the mortgage rejection. It's not something that can't be overcome. A lot of things we can correct in-house, but we have to take special care to make sure that these conditions are met so that your documents don't get held up as you record. We also have discounts for special situations. The most common would be the first-time home buyers rate. We give discounts on that. Government employees, they're open to discount. And if your people fall under these categories, investor rates, U.S. Armed Service rates, senior citizens, government, first-time, please let us know so we can make those corrections and make those exemptions so that it saves your client money. Short term, if they come back within a certain time, we also consider that. But the bottom line is, we're here to help you make sure that your clients are well taken care of. The discounts, so many times, are not applicable, and many times they're not even brought up until after the fact. In those cases, we've made adjustments after the fact. However, during the course of it, if there is any information that we could use to make sure that the closing goes smoothly and our clients are not impacted, please let us know. This is our staff, which I'm confident about. You can contact any one of them, but I'm not going to spend too much on them. But if you have questions, feel free to pick up the phone and call any one of them. I've given you a lot of things to mull over. These are building blocks to help you in your continued career, successful career in real estate. I provided you those blocks so you can build your own steps to success, where you finally close a deal and you successfully added another chapter in the success story of you helping improve the quality of life for your clients. If you notice the blocks, bionic, bionic. By no means am I calling you a bionic woman or bionic man, but I believe in all of you, you are bionic because you have that attitude that makes you successful. You have that passion that makes you care for your client, because each day you wake up, each day you pick up a file, you're convincing yourself, believe it or not, I can. Believe it or not, I can. Okay. bionic. Believe it or not, I can. That will make you successful. That will carry you through day to day. And I'm certain that after today, you'll be affecting more lives, improving more quality of life for those individuals that deal with you and put their confidence in you to make sure that their dreams come true. I saw a turtle. When I became involved with Premier, I adopted the turtle as my mascot. If you go to the zoo, the big turtles don't move if their heads are under the shell. Turtles only move forward when they stick their necks out, and I believe each and every one of you are prime examples of a turtle sticking their neck out to make sure that your goals are met, the goals of the clients are met, and you come to a successful ending. Just to let you know, we're here for you. Any questions, feel free to pick up the phone. There's no question that is immaterial. If we can help you resolve any issues you have, don't hesitate to pick up the phone and give me a call. I thank you very much for your attention. It went real fast. I may have blurted over some things that may confuse you, but it's not confusing. But thank you so much. Good luck in your continued success. If there's any questions, I'm more than happy to try to address it at this time.
Thank you, Carl. Aquino, are you here?
I am.
Okay, go ahead and turn on your video and we can ask. There are some questions.
Okay, my video is on. Can you not see me? Okay. Question 1. Thank you so much, Carl, for this informative session. I was diligently taking notes too. The first question is, okay, here we go. How is it possible that some sellers are transferring title to investor buyers, but the current mortgage is not being released or paid off? The mortgage remains in the seller's name.
If that happens, it's generally because the release was never filed correctly. That's number one. True escrow, you're supposed to pay off all those outstanding obligations, and payments are normally made. One issue we run into in terms of releases has been when name changes occur and they haven't refiled that with the Bureau. So they send a release in, but it's under a different name. There should be no situation that a buyer gets the property, and the mortgage continues. Because it's supposed to be paid off. If that happened, then my suggestion is contact whoever did the escrow,
Mhm.
call us, we can look into it. And then try to get a release, formal release to get rid of that application. The other issue is, it might run into second mortgages, HELOCs.
Mm,
If you're working with somebody that has a HELOC on the property, a line of credit, the rule of thumb is when we do a payoff, we're also required to get a signed acknowledgement from the seller to cancel that HELOC. They don't treat HELOCs the same way. They don't treat the line of credit the same way. You pay off a first mortgage, they send you a release. You pay off a line of credit, they don't send you a release until such time they receive an acknowledgement from the seller to cancel that particular mortgage. Because a HELOC is a revolving line. They get paid off, they're not sure if it's being sold or what. The mortgage is just being, so they can revive it again. So we have to send in that request acknowledged that tell them release the mortgage because the property is being sold, and the seller has to acknowledge that. In the absence of that, you'll have an existing HELOC on the property when the buyer tries to do anything with it.
thank you for that clarification, Carl. So there's a release on the first mortgage, but for a HELOC, although it might be paid off, the seller needs to say, we no longer want this HELOC.
Right, and escrow is required to get an acknowledgement from them to make sure it's clear.
Okay, thank you so much. Okay, we've got a few more questions, Carl. So question 2, to confirm, if an owner sells in the same fiscal year that the tax credit was filed for, the seller will be responsible to return the credit back to the county?
Yes.
Okay.
We had an incident the other day. The property was sold. Okay, it was sold in August. The buyer received notification that something wasn't paid. We reviewed it. They notified the tax office that the property was sold. Tax office canceled the home ownership, the home exemption, and requested the 175 to be returned. We paid back to the county. Initially, we thought that that was going to be perpetual, that they were not going to collect it back. However, we found out rudely that they do collect it back. We got it resolved. But the other issue is the tax credit, and this was due to age and medical reasons. And those are more expensive. We had one for $1,500 that had to be returned at the time of closing back to the county because it didn't follow the whole fiscal period. So when you're reviewing those reports at the real property tax, look at the history. If you see tax credits, that has to be deducted and the prorations would have to be used without that deduction.
Thank you. We have 2 more questions that I see. Where can we get more information on the RON, the remote online notary services?
That would be, you can look at the state statute that approved that, but all escrow companies can provide you information on how that normalized. We work with a number of people that are notaries. What happens is, if you're a client and you have if you're an agent has a client in Korea, let's say, they will be asking the Korean person a number of questions to try to validate that that is the actual seller or buyer. And they'll ask for passport documentation, things of that nature. If the notary is satisfied with the credentials that are being presented, the notary can then proceed to take what they call a virtual notarization. If the notary is not satisfied with the credentials, then they're not required to actually do it, have it done. So those are the issues, and it would require them to go to either vice consul or an embassy to get it notarized.
Thank you, Carl. Real quick.
Call any title company or escrow company. They will have the references for remote online notary. We were one of the later states to approve it.
Yes.
But it is approved. The state allows it now.
Okay. Thank you. Okay, more questions are coming through. So Carl, I hope you have a few more minutes. Question number 4. So should we always order a prelim title report before taking a listing?
We offer brokers free. Most of the companies do. You can certainly do that. If you're interested in working with us, give us a call. We can work with you to provide you either that or property profile to give you some idea of what the condition of title is.
Right. I think it's so important to order a broker's prelim early, even before, when you're talking to this person. That way you can clear title, so you're not scrambling at the last minute. Okay. Question number 5. In what type of scenarios are both regular and land systems used? I've seen that quite often.
Used?
It says used, yeah. In what types of scenarios are both regular and land systems used? This is the direct question that came from someone participating, but there are dual systems.
I'm going to assume it's a dual system problem.
Yes.
Okay. Dual system generally, because properties are been subdivided or re-subdivided, and sometimes you have adjoining lots, one land court, one regular, and they subdivide and they take a portion of the land court property to increase the size of the regular system property. This property now on the right side, that took some of the land, becomes dual side because you'd have to record it in 2 systems. Because that portion that was taken away is deducted from this subdivided lot, is added to this lot, but now you have regular system and dual land court, small sliver of land court. So they're together, so they're referred as dual system. The other issue is you have a large parcel and you build a condo on it. Okay. You build a condo on it. Each condo unit will be recorded in dual system because it sits on adjacent parcels, one land court, one regular system. Those are the most common. As far as individual lots where you have a land court added or a regular system added, that would be a problem. That's not frequent. Condos are more frequent.
Okay. So single family, it's less frequent. And that's why I see a lot in condos of dual systems. Thank you. Thank you, Carl. Okay. A few more questions. How can a lessor's name be on the title and the current owner owns the property in fee? Isn't that a leasehold? Sorry, I don't know. How can a lessor's name be on the title and the current owner owns the property in fee?
The fee, okay, the property is owned in fee. Okay. Akira, you own the property in fee.
Mhm.
You lease it to me. Okay, you lease it to me for whatever term it is. You work it out. So now I become the lessee. You're the lessor. Under the lease, you're lessor under lessee. So the real property tax will continue to show you as the fee owner, but it's subject to the lease you have with me, and I'll be reflected as the lessee in your real property tax statement. When the property is searched and the lease is being sold, we just reflect the lease interest. We'll show the real property, the property description, but we'll reflect only the lease interest because that's all we're working with, not the fee. So your interest as a lessor is protected. And we have to check that lease to make sure that when that lease is sold, that lessee now that wants to sell it, we have to check the lease to make sure that if it requires your authority or your approval to sell it, we obtain that. We have to check the lease. But the lease and the fee in owner will be reflected in real property tax all the time.
Right. But I think, sorry, maybe I'm just confused, but it says, how can a lessor's name be on the title? The lessor is the fee owner, correct?
The lessor is the fee owner.
Right. So
Fee
this
is
question, this question says, how can a lessor's name be on the title and the current owner owns the property in fee? I'm a little, because that would be the same person. No?
We're talking about lessor's name. Is that a lease to fee conversion?
I don't know who this question came from. Maybe I'll look at it in the Q&A later, but well,
When you're talking, but you're saying the fee owner and the lessor.
mhm.
The only time I would see that is if you have a lease to, if it's So will be converted. Now, let's see, the fee owner normally would be the same,
Right, the lessor and the fee owner are usually the same, and the lessee is different. Because
right?
that's, yeah, right, that's what I thought.
But they wouldn't be reflected the same way unless you have some other outstanding
Mm.
leases.
Okay, so the person who posted this question, if you can add a little bit more information in the Q&A, and we'll try to address it. Okay, moving on to the next question. Is there anything around reimbursement, an owner occupant buyer paying an investor rate on a residential A property for the time before the home exemption kicks in? Sorry, hold on. Is there anything around reimbursement, an owner occupant buyer paying an investor? Wait, an owner occupant buyer paying an investor rate on a residential A property for the time before the home exemption kicks in? Does that?
The home exemption kicks in at the start of each fiscal period. So July 1st of 2023, that begins the first half of the 2023-24 fiscal period. Now, if you're coming prior to that, you're coming off at the end of the prior fiscal. But if an investor is buying a home, that's a property that's owner occupied. If an investor buys that, there's a requirement to report that transfer to the tax office. At which time, when they're notified, then they terminate the home exemption, and the investor is paying the higher rate of taxes at that point. But they're not going to collect any shortage that was created by the home exemption. But he'll be responsible for it at a higher tax rate. So
Right.
normally, what we try to do is, if I'm buying from you, you're the homeowner, home exemption. I buy it at, let's say in October, home exemption is applicable there. I would have to pay the credit I'm working on is what is the assessed value less the exemption. And that's what the taxes should be prorated on. Because you're not going to be paying on the lower rate. As far as if you got a mortgage, you're going to have to collect. So there's a lot. So we try to resolve that within the escrow process.
Okay, thank you, Carl. Next question. If a husband dies with tenancy entirety, will the surviving wife keep that tenancy?
Yes. Under tenants by the entirety, there's a right of survivorship.
Right.
So if the husband dies, the wife becomes 100% owner. And vice versa, if the wife dies, the husband becomes 100% owner. That would hold true also with joint tenancy. Husband and wife hold a joint tenancy, they own 50-50. One died, it automatically right of survivorship. The difference between joint tenants and tenants by the entirety, under tenants by the entirety, the husband is protected against any gambling liens that he might have under tenants by the entirety. Under joint tenancy, that lien can attach to his 50%.
Right. So that is why, I don't know, I've been told that tenancy in entirety protects if you're a husband and wife or married. That's better than joint tenancy. But again, as realtors, we're not supposed to be advising on how to hold title, but that's in a nutshell.
No, basically, you just have to tell them one is right of survivorship, one is undivided interest, tenant entirety is 100% ownership. And they take it from there. As far as if you read the statutes on tenancy, it explains the protections under each one.
Right. Thank you, Carl. Okay. What if you order a broker's prelim from a certain escrow company, but end up using an escrow company, a different one for closing, which will happen?
It does happen. We just cry because you can't. You ordered a preliminary title report and you ended up going someplace else. The other issue is the change to the underwriters differ in terms of how they apply the requirement. One title company may say, okay, this is an issue. We may look at it and after explaining, working with an underwriter, feel that it's not an issue. Then many times the agent will transfer, not the title, I tell them hold the escrow wherever it is, we'll just provide the title insurance. So they don't have to make any inconvenience to client. But we've had that instance and vice versa.
Right. Okay, thank you, Carl. Okay, from the previous question about the lessor and lessee one. Okay, so they did have a mistake. It's not the lessor, but the lessee's name. So then it would be, how can a lessee's name be on the title and the current owner owns the property in fee? I
Oh,
don't,
because the lessee has interest. They're real simple. Who has interest in the property?
lessee has interest.
The fee owner owns the property in fee interest. But the lessee has interest under the lease. Where the fee owner provided a lease for that lessee to have full use of that property. So they both have interest. One is a lessee's interest, one is a fee interest. That's how it will be shown.
Okay,
Depending on what you're working with, the lessee can go out and get a mortgage under the lease. The fee owner can go get a mortgage under the fee.
right.
So depending on what interest we're searching on, that would impact how the title report is going to come out. But the
Okay.
lessee and fee owner both have interest in the property. One
Right.
by fee, one by leasehold interest pursuant to that lease. So they're both owners, but
Right.
different interests.
Thank you, Carl, for that clarification. Okay, one more question. If the property is owned as tenants in entirety, wait, why is this? And one spouse died before selling. I thought we answered something like this.
Are there? If
Yeah,
one-
if it's-
we had the husband and wife one. The husband died, goes to the wife.
Mhm.
Is that similar?
If property is owned as tenants in entirety and one spouse died before selling. Question mark.
Before what?
Before selling. So then it becomes, if the spouse died before selling, then it
Before
becomes,
selling. Before selling,
yes,
the wife can still sell. Okay,
right,
husband and wife signed the contract. Husband and wife signed the contract.
Mhm.
Goes into escrow. During the process, I'm just guessing, I'm formulating. During the process, husband dies. If it's land court, we have to petition the death. Because the certificate of title reflects ownership in husband and wife. So we have to amend it because that has to change the ownership. So a
Mhm.
petition would have to immediately be filed to the land court for
Mhm.
them to amend the certificate, note the death, so the wife becomes the sole owner. And the
Okay.
wife at that time can sell on her own signature without any disruption. Regular system is a little different. Regular system, we pick up the death if they died here locally. You know, we can go to the Department of Health, we get that information. So that basically, we're doing it, we're cleaning house without any additional step. If they're concerned over that, they can file an affidavit of death, affidavit to show that the person died. So that's not necessarily true if the person died here in Hawaii. If they died on the mainland or someplace overseas, yeah, something would have to be filed to be recorded, because otherwise you're gonna have questions down the road. How can only one spouse sign? But there's no reference to any death. We would be comfortable if we find it here in Hawaii, getting that information. Our title report would reflect the death of so-and-so as of such and such.
Okay. Thank you. There's another additional question to this question. Doesn't the tenancy change from the tenancy in entirety or entirety to severalty?
Yeah,
When
well,
one-
yeah, it does, because you are a single owner.
Right, so it will change.
It will, well, that tenancy doesn't matter in terms of that situation.
Okay,
It is gonna be tenants by the entirety due to the death, if she continues to hold the property.
Mhm.
Once you amend the certificate, single owner, tenants by the entirety, that's it.
So that's what it's automatic.
And then also when it comes to tenants in common,
Mm,
let's say you and I buy the property together. Okay, and you're supposed to get 80% because you put in more of the money, I only get 20.
uh-huh,
We record the document, you and I,
Uh-huh.
but it makes no reference,
Oh, to the
no
80/20?
reference to the interest. It just says
Okay.
tenants in common. I luck out, because that's my statute, I get 50-50. If there's nothing reflected, it goes automatically 50-50. 3 people, 1/3, 1/3, 1/3.
Ah. So if anyone is to buy tenants in common, and if there's a difference, you want to make sure that it is noted.
Right.
Okay,
It'll show Akina at 80%, undivided
Right.
Carl at 20%. If that's missing,
mm,
just say as tenants in common,
mm-hmm,
those
It's
owners become equal owners,
I see, okay.
which calls for a correction deed,
Mm-hmm.
which I'm gonna refuse to sign.
That's funny, Carl. I love all your things. It makes it click and stick now, right? Everyone's gonna be like, okay, tenants in common, make sure that we have the percentages down. Yeah. Thank you. Does anyone have any other questions? If I don't see any more pop up, I'm gonna let Carl, oh, I think I'm seeing a little bit more. Okay, Carl, do you have time for 2 more?
Sure.
Okay, question 1, situation. It's about a condo parking stall. Oh my goodness. Okay, here I go.
I hate parking stalls.
Yeah.
Okay, before you ask me the question, before you
Uh-huh.
ask me the question on parking stall, I'm gonna try to answer, okay, and see if I'm on the way. Parking stalls with condominiums have become a big issue. Most condominium property regimes, CPRs, reflect units will have a parking stall but not identified. It just said, there will be given 1 assigned parking stall. Some other CPRs will say unit 5 will have parking stall 16.
Mhm.
We look at the first documents out. The first documents out from the developer says unit 5 is parking stall 16, and it's in feet, and it's
Yeah.
carried that way. We don't have, we are more flexible on that. However, if it makes no designation on the CPR,
Mhm.
it's hard for us to say that's your parking stall, especially when parking stalls are issued by the association. It can be
Right.
moved around. It can be assigned by each PISO, so it's not permanent. So
Mhm.
we'll say, and we'll just follow the terms of the CPR and say unit is subject to 1 parking stall, but not given a number.
Mhm.
That number appears many times on contracts. Parking stall 1614 with parking, unit 1614 with parking stall 1, 2, 3. We
Mhm.
don't put 1, 2, 3 in. And we're always at, how come you don't put it in? And I said, there's nothing recorded that substantiates they have 1, 2, 3.
Mm.
So we always have a problem with parking stalls. I'm not sure that's what they question there.
The question was, okay, oh, this is a little bit different. Warranty deed conveys parking stall to a third party. The declaration is not amended to reflect the conveyance. So is the conveyance valid? And is it valid under land court, regular system?
Okay, when you say parking stall valid,
Mhm.
if it was conveyed in fee, we'd have to go back and forth, go back to the original CPR.
Right.
If that parking stall is issued by a deed subsequent to having received the parking stall pursuant to the CPR, it would be valid.
Mhm.
As long as the CPR said they can move it around. Where's that, Alawai Plaza or something like that? They've got parking stalls moving all over the place. So it was hard, but it's supposed to be, I thought that was key. When the parking stall issue, each situation will be treated individually.
Right.
There's so many different situations.
Yes.
But agents coming to me saying, how come I don't reflect the parking stall? Is because I have nothing to substantiate that.
Right.
As for the warranty deed,
Mhm.
I haven't come across any deeds that conveys parking stall. I've seen assignments with
Mm.
assigned between each other. But I haven't
Mhm.
seen a deed per se, specifically for parking stall.
Parking stall. Oh, it's like an assignment. Okay. this question said deed. Okay, another one by the same person is saying, can tenants in entirety be severed by conveyance to third party by one spouse?
One spouse cannot convey by itself. Tenants by the entirety requires both signatures.
Okay, yeah.
The only way that can happen when one spouse will sign, they have to go to court and get a partition order.
Mm,
And then at that point, the property is gonna be distributed at that point. So much for one spouse, so much for the other spouse, then one can go. But that's only by court order. By statute, tenancy by the entirety, husband and wife own 100%. It's not a 50-50. 100%, which requires both to sign.
okay. Got it. Thank you. Two more questions. The condo parking stall. Are parking stalls covered under the title policy?
If it's identified.
If it's identified on the CPR. Okay, got it.
But if it says, we just say you're guaranteed one
Fine.
parking stall, we're not saying which parking stall it is.
Got it. Okay.
It is covered in the policy.
Okay. Final question. Where can we find a thorough descriptions of tenancy? Where can we find a thorough description of tenancy? I think that's all on
In
all
the
escrow.
statutes, I don't know the exact state statutes, but the general rule of thumb I follow is several things. One, joint tenants, equal ownership between each party with the right of survivorship. If one died, it passes on. Not a sale, because you can sell your interest in joint tenants.
Hmm.
You have three people, one sell, 1/3 is undivided, the other 2/3 remain the same, so they own. Tenants in common, you can identify specific interest for each. It has to add up to 100%. And it doesn't have to be equal.
Mm.
And they're undivided. It doesn't pass on by death.
Mm.
It goes on to surviving heirs and never see. And tenants by the entirety is basically husband and wife, 100%. Hawaii is not a community property state. A lot of people ask that. How that works in California, I'm not sure. But Hawaii is not a community property state. But the statutes covers all of that.
Okay.
And we have some write-ups on tenancies. If the people want it, they can always contact me. I can get them copies of that.
Okay. Thank you so much, Carl, for taking the time to do this presentation, educating us, and then answering all our questions. I really, really appreciated it. And everyone thoroughly enjoyed it. I think we had like over 100 people on this Zoom call. So thank you so much, Carl.
Well, for me, I appreciate the opportunity. It's not something that I'm used to. In my former life at the Bureau, realtors were basically bothersome because asking me to do certain things. And of course, I was on the other side of the counter where you can't go anywhere else, so you can get mad at me, but you still got to come back to me. But now I have a different hat on. I have to be nice to you people. Not that it's hard to do. And I'm enjoying. I mean, to me, educating the agents, to give them some ammunition for them to be more productive, more confident when they talk to clients. That helps us. Because the transaction comes in, they have an understanding. It doesn't create too much issues for us. So education is my primary goal at this time. Yeah, certainly we'd like the activity as it comes to fruition. If we don't, that's okay. As long as we've given you guys additional ones. And remember, you guys are all bionic.
I love that. Thank you. Thank you, Carl. Bionic. Believe it or not, I can, right? That's what it is. Okay. Thank you again, Carl. Thank you everyone for tuning in, and please do your evaluation at the end, or Crystal will send the link because it really helps us. The leadership team reviews and tries to create better content for you. But Carl, you were amazing. Thank you so much.
Well, I appreciate it. And if there's anybody, I do anything and everything to help you guys out. One of the one of the thoughts that I came about was just having, if you guys just want to meet from, but you need a screen, because how to do a petition to no death at land court.
Mm,
It's real easy to do. And you can do it on your own for your client.
really?
Yeah.
Okay.
It's simple. I'm not going into the room, ones that create more problem, but to know the death, to know the marriage, those are real simple things to do. And that's another part that I feel that I can arm you with. So if your client comes in, oh, you know, my partner passed away or whatever, over there to petition, you can sit down, whip it out, ready to record.
Okay, well, maybe that'll be our mastermind in 2024, Carl. We'll have you come back and educate us even more.
Well, I
Thank-
appreciate the opportunity. Thank you so much.
Thank you again, and thank you, everyone, and have a wonderful Tuesday. Thank you, Carl. Thank you,
Thank
everyone.
all.
Okay, aloha.